Good afternoon slash evening, everybody. This is Adrian with PrepAgent. Hope everybody's having a great Thursday. Can you just pop in a thumbs up if you can hear me, or say hi, say what's up? Just want to know that I am streaming and we'll get rolling here. Hi, Ann. Welcome, Alicia. Howdy, Larry and Mike slash Lisa. How's everybody doing? What? So we're starting on a slightly different screen today. You'll notice I'm logged into the dashboard here at PrepAgent. I'm going to try and do some complicated stuff here. So if the screen gets a little weird, sorry about that. But I think it should all go smoothly. Hola, Jose. So what we wanted to inform you guys about, there's a couple things we wanted to talk about today. And the first one is the referral program. So you may have seen, most of you will have a link somewhere up here, or sometimes a few links with little announcements. One of them is about our referral program. If you've already closed that like I have, you can go ahead and click on the More menu right here, and then select Refer and Earn Money. And this is what we wanted to let you guys know about. This is for members only. And if you know somebody, if you're taking a pre-license course, you have somebody in your class, or you just know somebody else who's trying to take the exam, you can refer them to PrepAgent. When you're logged into your account, we'll give you a unique link here, and anybody you refer will get 20% off their package, and then you will get either a $10 Amazon gift card if they purchase basic, $15 Amazon gift card if they go with deluxe, or $20 Amazon gift card if they go premium. And there's no limit to the number of people you can refer. So we're pretty excited about this because a lot of you guys have checked in with us to let us know that you're referring people, and we want to be able to give back to you guys for doing that. It helps us out, obviously, grows the community, gets more subscribers on the platform. But you guys can also get some great Amazon gift cards as well. So that is one of the things we wanted to show you. The other one, I guess I can't actually show you. So give me just a moment here to switch my view. The other thing that we wanted to talk about, I'm going to post a link for in the chat window. And this is a short video that Joe did asking you guys, once you pass your real estate exams, if you want to give us a short video. If you go to the link that I just posted up there and click on it, watch the video. Basically what we're looking for, and the opportunity that we're giving you guys, is to, once you pass your exam, to get your name out there. We'll post your video on our YouTube platform. We'll put any links that you want into your website, your blog, whatever you've got going on. We'll give you the opportunity to say anything that you want to promote your business. And then it'd be great, if you offer some tips or advice to people who are still taking the exam as well. So it's a chance for you guys to get your names out in front of just about 70,000 people, because we're almost there with YouTube subscribers. But we're also going to hopefully give other people that are taking the exam just a little bit of a pep talk or advice, or anything that you wish somebody would have told you before you took the exam. So those are the two announcements for the day, and let's go ahead. Alexa says, sweet, I dig that. That's awesome, Alexis. Hopefully more of you. We'll get into that as well. I mean, we want to get to know you guys a little better as well. So before we get started on the board here, I just wanted to cover freehold estates really quick. So what is the most ownership that you can have in real estate? What do you guys think for that? What is the most complete ownership that you can have? Anne asks, how come you can't go back and watch the replay? If you go in through your account, Anne, then you should be able to access replays under previously recorded webinars. All right, I see Mike/Lisa first on the board with fee simple absolute. Exactly, that is the most complete ownership that you can have in real property. What is it called when you have conditional ownership of real property? What do you guys think there? Conditional ownership of real property. What is that called? Oh, Larry, really close. Samantha, you're close too. Elaine and Michael first up with fee simple defeasible. Very similar to fee simple absolute. Defeasible means it's defeatable, which means that there's a condition placed on the title. And we'll get into some questions that are an example of that. But it means there's a condition on the title that could result in you losing title to that property if that condition were triggered. And what's the other main type of estate that we talk about with freehold estates that is measured or determined by the length of someone's life? What do you think? A type of property ownership that is determined by the length of someone's life. Mike, nice job. Mike/Lisa, first up on the board again. Fingers of fury today. A life estate is what we're looking for there. That's when your ownership is determined by the length of someone's life. So normally, with the average life estate, the length of ownership is measured by the life of the life tenant, right? Does anybody know what it's called when the length of the life estate is measured by the life of someone who is not the life tenant, by somebody else? What is it called when you have a life estate and the length of that life estate is measured by someone else's life, not the life tenant? Does anybody know? This isn't one we come into or run into very much. Oh, Mike/Lisa back on it again. Pure autre vie. That is exactly it. Life estate pure autre vie is what it's called, and that's French. Supposedly French for someone else's life, I think, or something like another's life, maybe. And there are some pretty interesting, some very unique characteristics about those. I think we might run into those later. So if you have a life estate, and when that life estate ends, when that life tenant dies, if the estate goes back to the original grantor, does anybody know what that process is called? Anybody know what it's called when the life estate... Oh, Liberty, first up on the board. Nice. Taking the title away from Mike/Lisa. Reversion is what it's called when the original grantor gets the estate back after the life tenant passes. So last one before we launch into the questions on the board. What is it called if the life estate passes to a third party, a completely different person, after the life tenant passes? Does anybody know what that's called? Life tenant passes and the estate goes to somebody else. Oh, Mike/Lisa wasn't going to be beat again. Remainderman, exactly. Liberty right there too. Well done, everybody. You got your estates down. I think you're ready for today's quiz. So let's start with one of Joe's better questions. Xena granted a property to Ungrilda, but because she knew that Ungrilda had a drinking problem, she told her that there was a condition. The condition was that the property would be forfeited if alcohol is sold on the promise. Ungrilda would have which of the following estates? What do you all think? We just talked about this. A, life estate. B, fee simple defeasible. C, fee simple absolute, or D, estate in sufferance? Nice, everybody's getting this right. Xena granted a property to Ungrilda, but because she knew that Ungrilda had a drinking problem, she told her there was a condition. The condition was that the property would be forfeited if alcohol is sold on the premise. Ungrilda would have which of the following estates? The answer is B, fee simple defeasible. Nice work, everyone. Moving on, next on the board, the government's right to make laws and regulations for the general welfare of the public is known as A, eminent domain, B, escheat, C, the bundle of rights, or D, police power. Diana says, interesting name, sounds like a fairy tale. Totally agree. Pretty sure that property that she bought was a gingerbread house. Okay, the government's right to make laws and regulations for the general welfare of the public is known as D, police power. I did see a couple of B's thrown up there, or maybe it was C's. But the bundle of rights, that's related to property ownership. It's the rights you get with property ownership. And escheat is the government's right to take over a property if there are no heirs. When somebody dies and has no heirs to pass on or no will. And next up, which of the following would be the best and most complete definition of the term encumbrance? A, any action taken relative to property other than acquiring or transferring title. B, the use of property by a debtor to offer creditor security for a debt. C, anything which affects or limits the fee simple title to property. Or D, the degree, quantity, nature, and extent of interest which a person has in real property. What does everybody think here? Dulce, I thought you said you were ready. What do you think? Dulce says C. Which of the following would be the best and most complete definition of the term encumbrance? The answer is C. Anything which affects or limits the fee simple title to property. Great job. I think everybody got that too. Nice. We're on a roll. Oh, let's go to a different question for next. And that is, once a judgment has been obtained against real property, a plaintiff would obtain which of the following in order to cause the property to be sold? Tricky one. A, a writ of execution. B, an estoppel. C, a lease pendens. Or D, an attachment. What does everybody think here? Getting a bit more legal on you. Once a judgment has been obtained against real property, a plaintiff would obtain which of the following in order to cause the property to be sold? And the answer is A, a writ of execution. A writ of execution is the court order to sell property to satisfy a judgment. A bunch of people threw up lease pendens there. Lease pendens is a lawsuit pending, Latin for lawsuit pending. And basically when you're going to see that is if you're a buyer and you go to buy a house during the sort of discovery period, it's found out that there is a pending mechanics lien on the property that you want to buy. That is called a lease pendens. It's like a record, I guess, that's filed with the county recorders, letting any potential buyers know that there's a potential encumbrance on the property. So a little bit different. No problem. For those of you that got it wrong, that's why we're doing these. Hopefully now you will remember when and if it actually comes up on your exam, right? All right, next up, more estates. A freehold estate consists of, this is a which of the following type of question. A fee estate. B, a leasehold estate. C, an estate from period to period. Or D, an estate at will. Anne asks, wouldn't that also be like foreclosure, talking about the writ of execution? Foreclosure is sort of like a name for a much longer process, but probably a writ of execution would be included in that foreclosure. All right, a freehold estate consists of a fee estate. Nice one there too. Lots of participation today. That's awesome. Looks like we're getting 20 to 30 responses on every one. Looks like there's 54 people online though, so anybody else, feel free to chime in too. All right, next on the board, if a person leased a store for only 6 months, that person would have an A, estate at will, B, estate at sufferance, C, estate for years, or D, estate from period to period. This one can be tricky if you sort of take these names at face value. Let's see how everybody does. Nice work. If a person leased a store for only 6 months, that person would have C, estate for years. Almost everybody got that one right. This one gets confusing sometimes because it sounds like it could be an estate from period to period. If that was the case, though, the question would probably say something more like, if a person leased a store in 6-month increments and had to renew every 6 months, that could be an estate from period to period. Anthony says, summer rentals, absolutely. And Dole says, oh, because it's fixed time? Exactly, because it's a fixed amount of time. That 6 months is fixed, starts now, ends 6 months from now. Next up, a joint tenant can dispose of an interest held in real property by all of the following ways except A, gift, B, lease, C, sale, or D, will. Lisa beat everybody that time. I didn't even get to read the question. Got some fast fingers on the boards today. A joint tenant can dispose of an interest held in real property by all of the following ways except D, will. Joint tenants have the right of survivorship, which means that they cannot will their interest in a property. Rolling on. All right, let's see if this will trip anybody up. Restrictive covenants that run with the land. A, apply to and bind all successive owners of a property. B, apply only until the developer has conveyed the title. C, can be removed by a court of competent jurisdiction. Or D, are no longer effective when the title is transferred. What does everybody think here? Nice job. Anne's got the fast fingers in this one. Restrictive covenants that run with the land. Give everybody a chance to catch up. Pretty solid consensus here. Restrictive covenants that run with the land. A, apply to and bind all successive owners of the property. The keywords there, the trick there is that we're talking about run with the land. Anytime we're talking about something that runs with the land, it's going to apply to all successive owners of the property. Easements, for example, run with the land. Restrictive covenants can be like HOAs, or they can be developer restrictions. Anne says, guess she must be ready for her test on Tuesday. Are you getting a test? Did you finally get it scheduled, Anne? Or are you just teasing? Next up, all of the following are examples of police power except A. Zoning ordinances, B. City planning requirements, C. Restrictive covenants, or D. Building codes. What do you think here? Good luck, Anne. It's awesome. For those of you that are new or don't know, Anne's been trying to get scheduled for an exam forever, since like the start of the year. No jinxing. No jinxing. Only good luck to you, Anne. Cynthia says, go and go. Okay, all of the following are examples of police power except C, restrictive covenants. Like we just talked about, restrictive covenants are usually imposed by like an HOA or by the developer of housing development. Lisa says, Elaine got that one. Way to go, Elaine. Sorry about that. All right. Land that is subject to an easement is said to be A, appurtenant, B, encroached, C, restricted, or D, encumbered. What do y'all think here? Land that is subject to an easement. Might have thrown some of y'all off with our runs with the land conversation. Land that is subject to an easement is said to be encumbered. An easement is oftentimes appurtenant to the land. You have appurtenant easements, but what we're talking about here is encumbered. That land is encumbered when it has an easement on it. Any sort of a claim, lien, or charge is an encumbrance. Elaine says, that one got you. That one got a lot of us, Elaine. I think, like I said, I think that's because we were just talking about something super similar, and then the language of the question was really simple, and it was really easy to make that connection. That is, a good cautionary tale for the exam, right? It is important to come into each question and make it its own thing, to not carry any of our baggage from previous questions into it. It is important to read them carefully and completely because you pretty much only get the one chance per exam. But if you miss one, you got to move on. Don't want to take it too hard and let that affect the next one. So up next, we're all going to get this one right. Right, everybody? Who usually sets deed restrictions on a subdivision development? That's a little tricky too. A, the permanent lender. B, the FHA. C, the state and local ordinances. Or D, the developer. Michael Caudell says, ha ha ha, thinking is good for us. Yeah, that's a great call. Thinking is good. Important that we bring our thinking into the exam. Right. Who usually sets deed restrictions on a subdivision development? D, the developer. The keywords here are deed restrictions and subdivision development. That's usually going to be the developer. Those are like sort of the restrictive covenants we were just talking about. Some people did throw up state and local ordinances. Normally, if you're going to see restrictions related to state and local ordinances, that's going to be zoning, right? So you want to kind of mentally tie those concepts together in your brain. Oh, we got Mike on Mike crime. Keep it under control in the chat, people. Ha ha ha. All right. Time to get back on track. Oh, more restrictions. We're going to have our restrictions and covenants and conditions down by the end of this session. Private restrictions on real property can be written either as a condition or a covenant. Which of the following is most correct concerning such restrictions? Violation of a condition, A, violation of a condition can result in penalties which are more severe and can result in loss of title. B, violations of such penalties are a criminal offense. C, they become public restrictions upon recording. And D, violation of covenants can result in penalties which are more severe and can result in loss of money only. I would say on this one, read the answers pretty carefully, and it's common sense when sort of what's being said actually falls into place for you. I don't know if that helps or makes it more complex. I'm trying to help here without giving the answer away. Private restrictions on real property can be written either as a condition or a covenant. Which of the following is most correct concerning such restrictions? The answer is A. Violation of a condition can result in penalties which are more severe and can result in loss of title. So we'll just spend half a second explaining the difference between A and D. Everybody got that it was one of those two. But usually when we're talking about covenants, we are talking about things like deed restrictions or the covenants placed by a developer or by an HOA. So if you violate something like that, if you don't have your lawn mowed and the HOA is like, oh, we have a covenant that says you must mow your lawn to right in between 1/4 and 3/8 of an inch every other week. They can fine you, but they can't take your title away, at least not that I'm aware of. On this top one, what we're talking about are conditions like zoning is a condition, or a defeasible, fee simple defeasible title. If there is a condition on your title, then you can actually lose your title. So hopefully if you guys run across this concept again, something there will click, but we're talking about A. And Cynthia says, too much. I totally agree. That's way too much, and it will probably never come up on your exam now that we just spent 5 minutes talking about it. All right, moving on from all the restriction talk. The owner of a single lot is trying to show that exceptional circumstances concerning an intended use of the property are applicable to his property. The owner is also trying to show that the exception is not detrimental to the public. The owner would probably petition the Planning Commission for A, a variance, B, rezoning, C, a permit, or D, a novation. Ooh, Mike and Mike competing for first answer. Marine Mike had it, but that was the wrong answer. The keywords here are the owner of a lot, trying to show circumstances. Yeah, that's too hard to parse. The owner of a single lot is trying to show that exceptional circumstances concerning an intended use of the property are applicable to his property. The owner is also trying to show that the exception is not detrimental to the public. The owner would probably petition the Planning Commission for A, a variance. Does anybody know what it's called when a building exists and the zoning changes so that the building no longer complies with the zoning, but that building is allowed to continue existing anyway? Anybody know what that one's called? The building exists, the zoning changes, and The building is allowed to continue. Ooh, Alexis got one of them, called grandfathered. Liberty got the other one, non-conforming use. Nice. Threw you guys a curveball, and you banged it out of the park. All right. Let's go with something a little bit shorter this time. A lessee is released from the obligation to pay rent if the A. owner sells the property, B. owner declares bankruptcy, C. lessee is constructively evicted, or D. lessee abandons the premises. What do you think here? Mike/Lisa first up. Marine Mike right behind. Marine Mike says again. Fingers of fury. All right, everybody's back on track. A lessee is released from the obligation to pay rent if the C. lessee is constructively evicted. Your lease, you're no longer held to your lease. What about this one? Exposure to lead can cause what kind of bodily damage? A. Lead can cause damage to the blood. B. Lead can cause damage to the kidneys. C. Lead can cause damage to the kidneys, brain, and blood. Or D. Lead can cause damage to the brain. What do we now know about exposure to lead? It can cause what kind of bodily damage? C. Lead can cause damage to the kidneys, brain, and blood. Questions like this, I'll often get feedback about like, well, they're all right. So why doesn't it count if I choose A, B, or D? What's important to remember about this kind of question and why we put them on your practice exams is because they're not uncommon on actual real estate exams where you are asked to choose the most correct answer. And that's another reason why it's super important to read everything completely and carefully. So, like Anne says, you know better than to eat lead-damaged kidneys, brain, or blood for zombies, I guess. Definitely want to be aware of that. All right. Another short one here. A recorded deed. A. All of the other options are correct. B. Must have been acknowledged. C. Creates presumption of delivery. Or D. Gives constructive notice. Ooh, this one's a curveball. Christopher Seal, first up on the board. Anne says, oh yeah, iZombie's on tonight. Is that still going on? And I watched like the first season and a half. Thought it was pretty good. I dug it. Okay, a recorded deed. A, all of the other options are correct. A recorded deed must have been acknowledged, gives presumption of delivery, and gives constructive notice. Another tricky one. And this one's a good one that we have that up here. Because I probably would have said D2, gives constructive notice. Nice. Cynthia says, hurried and got it wrong and slowed down, focused and got it right. Well played, Cynthia. All right, last one. Do another story problem. All right. A parcel of property was purchased by two friends. The deed they received from the seller at closing conveyed the property by name to each of the two friends without further explanation. The friends took title as which of the following? A. Community property owners. B. Joint tenants. C. Tenants by the entirety. Or D. Tenants in common. What do you all think on this one? Give you a little hint without further explanation. So the deed conveyed the property but didn't classify the type of ownership at all. Only one of these applies. The other ones all require expressed interest in creating that type of property. So I'm going to read this once more for people on the replay or who are just listening. A parcel of property was purchased by two friends. The deed they received from the seller at closing conveyed the property by name to each of the two friends without further explanation. The friends took title as which of the following? And the answer is D, tenants in common. Nice job, everybody. After slowing down and rereading, I think most of us got it there. We did see a few B. Again, the difference in these are that joint tenants and then tenants by the entirety and community property owners, those usually relate to state-specific types of ownership related to marriage, right? So when you get married, and depending on your state, you may be community property, tenants by the entirety, or joint tenants. And to my knowledge, those all require express interest in creating that type of joint ownership. Hopefully that explains the difference there, everybody. And that's going to do it for today. Thank you so much for joining in. We had great participation today. Lots of people answering questions. Lots of new ones. We had the mic on mic battle. One of the mics not really being a mic, but love to see that. Not the competition, but love to see us pushing each other to get a little bit better, to process this more completely, to process it quicker, and just to do better. That's why we're so proud of the community that we've created here and are so grateful to all of you guys for being part of it. So I want everybody to have a great Thursday night. Get plenty of rest. We'll be back tomorrow at 9 a.m. with vocabulary. Not sure if it'll be me and Joe, but we'll see you there. Everybody have a great night and take care. It's Adrian with PrepAgent signing off.